community control. You'll be ordered to have no contact with Mr. McKenzie, the victim. In this case, as a condition of community control, you are to wear a GPS device for the first 90 days. You'll be on house arrest with work release.
So that's what the defense thinks the sentence is going to be. That's what the state thinks the sentence is going to be. That's what they think they negotiated.
And you will serve the first 7 days of this term of probation in our county jail. You are ordered remanded.
We had agreed sentence.
You didn't agree with me, Mr. Kinlan, and I am charged with sentencing.
I understand he's mad, but the judge is right. You didn't agree with me. We all know, every lawyer knows walking into that courtroom, if the judge doesn't agree with the sentence, too bad. Whatever you negotiated doesn't really matter, and that's a risk you take.
At this point, Your Honor, we're going to make a motion to withdraw the plea. We'd rather go to trial.
Because you don't like the sentence?
No, because we don't like the way the court has interpreted the facts.
So what can a criminal defendant or criminal defense attorney do in this situation where this is what happens? The options are basically withdraw the plea, appeal the sentence, try to get a supersedious bond. Problem is, you can't just withdraw a plea that's already done. So in order to withdraw the plea, there has to be some kind of manifest injustice, which we remember that from the Karen Reed case that occurred. And it's got to be usually that the client didn't make the plea knowingly, voluntarily. And he could say, well, we didn't know you were going to give that. Everybody knows what's happening. He wants to withdraw it because of the 7 days in jail. The judge is like, why are you going to withdraw it? Because you don't like the sentence. You can't. That's not a legal reason that you can withdraw your plea.
Mr. Kinlan, did you talk to me about sentence before you pled your client?
You were not available.
Did you make any effort to talk to me in the last 6 months about how I would sentence your client?
Yes.
No.
We did have an agreed sentence from the state, but asked the court to go along with the agreed sentence as it's a condition of plea.
Didn't ask me. Sorry.
The plea is not knowingly voluntary.
Your bad practice is not my problem.
I don't think it's my bad practice, Your Honor.
Your bad practice is not my problem. Ouch. That hurts, right? That he says that. But it leads me to something else she can do. She can file an appeal. Can she argue because of his ineffective assistance, that's why her sentence is unfair and that's why she ended up in jail? Well, potentially. But she's going to jail right now. So then she'd have to get a supersedious bond, which would let her be out of jail while on appeal. Sometimes that can take some time, and her sentence is only 7 days. So you'd have to do an emergency. You'd have to rush that and try to get her out, which she could spend 1 or 2 days or even a week in jail already. And then what's the point of appealing it if you've already done the jail time? So all of this is not good.
We're done.
I have so many thoughts. If you think you're going home and instead they throw you in jail, that's a big deal.